Yes.
Thank you. Let me bring you up to date on where we are on the outsourcing. Let me start by saying Sandy mentioned the figure of 700,000 that's anticipated to be saved. And as you may recall, there was some discussion that the savings would be approximately
It is. He misspoke.
That was direct
The
savings.
savings are 1,900,900. It's slightly.
1,900,000.
Yes, 1,900,000. It's not
9,000.
700. 700 is direct.
Direct savings,
Right.
employees.
But as I was saying, you mentioned the $700,000 in savings, and I wanted just to point out that that's direct costs. There are additional anticipated savings of indirect costs, which include legal fees, which unfortunately, for reasons that I'm about to discuss, you're not going to see right away. As you know, the Galaxy outsourced several departments and a number of employees. Local 124, representing the employees, filed a complaint with the National Labor Relations Board, the NLRB, challenging that. The NLRB conducted an investigation. Now, it's the policy of the NLRB that when there is a factual dispute, the only way to resolve the factual dispute is to have a hearing, and the only way to have a hearing is for a formal complaint to be issued. So as a result of the investigation, the NLRB was unable to determine what the nature of the actual conduct of negotiations and what the actual facts were. Representatives of Local 24 have one version, and our witnesses have another version. Because of that, the board issued a complaint which will allow the appointment of an administrative law judge by the National Labor Relations Board, who will then conduct a trial. This trial is scheduled to commence in December 13th. The administrative law judge sits without a jury. It's a civil proceeding. Witnesses will be sworn in, just as in a regular trial. There'll be evidence presented. It's on an accelerated basis, so there is no pre-trial discovery procedures. The hearing will commence December 13th. There's no way to know how long it will take to conclude the hearing. After the hearing is concluded, the administrative law judge has up to 90 days to render a decision. Whatever decision the administrative law judge renders is not self-effectuating, which means whatever the administrative law judge decides can be appealed by either side. The way the law works is that appeal is to the National Labor Relations Board, which is an administrative body in Washington. The appeal goes to the NLRB. One little wrinkle is, as of the end of this year, there will only be 2 legal members of the NLRB, which by statute has to have 5 members. The Supreme Court has determined that the NLRB cannot legally issue decisions if there are only 2 members. There is currently a deadlock in Washington. The president has submitted nominations, but the Senate consideration of them is being blocked, and that is anticipated to continue for the foreseeable future. So, if in fact there continue to be only 2 members of the NLRB will not be able to consider the administrative law judge decision, and that decision will be held in abeyance until the NLRB is legally constituted and capable of sitting. Once that happens, and the NLRB does not have a deadline as to how long it has, could take 6 months, could take 6 years. Once the NLRB makes a decision, that decision is also appealable to the courts, to the United States courts, the federal court, and by either side. And until a court of competent jurisdiction of the United States issues an opinion, again, the NLRB decision is not binding and doesn't take effect. It's not, as we say, self-effectuating. So, until a federal court of the United States issues a final decision, the case remains open. And this process could take, as I said, several years. So there is no reason to anticipate, unless there is some sort of a settlement in the interim, that that the status quo will change anytime in the near future. The only way it will change is if there is a settlement. If this is played out fully in the courts, you can anticipate it will take several years. We are in preparation now. We are commencing, we have already commenced and will continue to commence preparation for trial, and we'll be ready to proceed on December 13th.
Has the GTCA or through its whoever reached out, or has there been any attempt at a settlement?
Because settlement negotiations are not admissible in evidence, even the existence of them is confidential.
Okay, good.
I would prefer not to discuss
Okay.
whether or not there are any.
Knew it was a question out there, okay.
But to all the people, you should know, right? The answer.
Right, exactly.
Knew there was a question.
All right.
As the saying goes, I cannot confirm or deny that there are settlement negotiations
All right.
underway.
Anything else?
That completes the report.
Tell us about